Good afternoon, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. We're going to try to finish up this information I was doing a video on yesterday. I got cut off and took them a while to repair the line so we get back on, so I wasn't able to finish it yesterday. As well as my apologies, I was not able to hold my regular Monday night Zoom meeting last night, so I will do the continuation of that on Thursday. Sorry we missed this Monday night Zoom. In the meantime, we'll get back to where we left off yesterday in regards to talking about the specific decisions of what is money and what is legal tender in regards to the gold clause and all that. And yesterday, if you remember, or if you go back and watch that other video, you'll see at the end there where I got cut off. We were discussing, oops, sorry about that, folks. We were discussing this right here in light of the holding of Guaranty Trust Company versus Henwood. And yesterday, before I go any further, I made a misquote in the video. I said it was Title 31 of the United States Code 518, when it is in fact 5118. And 5118 is this here where we're talking about the gold clause and consent to sue. So just to make sure everybody gets that right. Correction on yesterday's video, it is not 31 USC 518, it is USC 5118. And yesterday we were talking about this part right here. As of October 27th, 1977, legal right here, legal tender for discharge of debt is no longer required. That is because legal tender is not in circulation. At par with promise to pay credit. What they are doing is they are promising to pay credit. Whose credit? Whose credit? It's not their credit because they are partaking of the value of what is known as legal tender, which is not in circulation, and giving you a promise to pay so long as they get to use credit of that legal tender. Therefore, requirement of repayment of debt is against public policy. This is Public Law 97 or 9310, I believe. Let's double check that. Maybe it's 9710. Huh. Anyway, the public law that goes along with the HJR 192 is what we're looking at here in regards to legal tender. Can't be used for repayment of debt because we're not using legal tender in circulation. And therefore, since legal tender was not loaned, nor in circulation, they cannot demand payment in any particular form of coin or currency or legal tender. And repayment or payment need only be made in equivalent kind, a negotiable instrument, that such as a promissory note, letter of credit, etc. What they are doing is they are performing a monopolization, saying that you can only use their instruments under obligation or other security of the United States. However, the fallacy of that is that because the public law says that such as promissory notes, letter of credit, etc., need only be made in equivalent kind. The equivalent kind would be me merely writing out an IOU. Who is you and who am I? Distinctly clarifying the parties involved, the values, and why the IOU is equivalent kind. Because they're just symbols written with ink that are absorbed into a piece of paper and appear on the surface of that paper. That is all it is. Nothing else, nothing less. So again, that correction was Title 31 U.S. Code 5118 and not 518, which is the gold clauses in consent to sue. In this section, gold clause means a provision in or related to an obligation alleging to give the obligee, yourself, a right to require payment. Alleging to give. You already have the right to require payment. You already have that right. They have abrogated it through use of their obligations. You are not obligated to use their obligations. They're theirs, not yours. Gold, a particular United States coin or currency, and not coin or currency of the realm. United States money, measured in gold, not the legal tender, but the money measured in gold. Or a particular United States coin or currency. Redundant statement, but this little word right here, or. A particular United States coin or currency is the same as United States money measured in gold. That itself is the definition of a particular United States coin or currency. It is merely a money measured in gold. Measured by the United States as a par value of gold itself. Public debt obligation means a domestic obligation issued or guaranteed by the United States. Domestic, United States. United States government, you notice, all capitalized, is the corporate board known as Congress, and not the executive board, which would be in lowercase, to repay money or interest. Period. Okay. As you can see at the top of the page, I've got various different pages we're going to go through here. There's several of them. These are definitions, so we're going to go through. That was my fault, folks. We're going to go through, and we'll reread this stuff by statute, such as 12 U.S.C. 1813A1. That's the gold clause the obligations we read. Title 3115 or 31, Section 5118 is the gold clause we just read. We're also going to take a look at definitions under Code 1812, Title 12 of the U.S. Code 1813. This right here. This one right here. Because it specifically talks about certain definitions. And in this one here it says A1. And A, definitions of bank and related terms. So this extends beyond the definition of banks and goes to related terms as well. One says bank. The term bank means any national bank and state bank and any federal branch and insured branch. So a national bank, it means any national bank and state bank, comma, those go together, there's a nexus. The state bank can only operate with a contract with a national bank because they are using the currency of a national bank. National bank currency are Federal Reserve notes. So the state banks using the property of the Federal Reserve notes have to have a contract with the national banks, which is a quasi-contract via the national bank contract with the Federal Reserve. And any federal branch. National bank is a federal branch bank. And insured branch includes any former savings association. We're going to go down and we're going to look at the nicest one I know of in all of these sections. Receiver. The term receiver includes a receiver, liquidating agent, conservator, commission, they get a partial value of the total sale, person, or other agency charged. Guess what, people? Are they charging you with civil offenses when they've already been charged as the receiver? Who is the receiver? with the duty of winding up the affairs of a bank or savings association or of a branch of a foreign bank. What is a foreign bank? We haven't heard that one in this, have we? How come they don't have foreign bank in there? They have state non-member bank. They have national non-member bank. Definitions relating to non-member banks. National non-member bank. How can they be a national non-member bank? State non-member bank. Means any state bank which is not a member of the Federal Reserve. Do state banks have their own currency then? What is that currency? Notice again, they haven't mentioned anything about a foreign bank until we get down here to receiver. Foreign bank. Foreign bank is listed not alphabetically, but down lower. It says foreign bank. The term foreign bank has the meaning given to such term by Section 1B7 of the International Banking Act. Oh, we've already got it. Look at this. Definition codes for, what was that? 7? Foreign bank. Foreign bank means any company organized under the laws of a foreign country. Means any country other than the United States, and includes any colony, dependency, or possession of any such country. So it means any country other than the United States. So a territory of the United States is a different country than the United States. Are you getting it? Puerto Rico is a different country. Guam is a different country. American Samoa is a different country. Or the Virgin Islands is a different country. Which engages with gauges. N means with. Gauges. Who's gauging it? Are you using your own discretion or are you using theirs? Which engages in the business of banking or any subsidiary or affiliate organized under such laws of any company. Company. For the purpose of this chapter, the term foreign bank includes without limitation foreign commercial banks, foreign merchant banks, and other foreign institutions that engage in banking activities, usually in connection with the business of banking in the countries where such foreign institutions are organized or operating. Banking activities usual in connection with business of banking in countries where such foreign institutions are organized or operating. Again, people, all banks I don't care how they describe them, operate as trust companies. This is why you have to establish your own private express trust as a foreign entity from the United States and all other countries. As a foreign merchant. You have a right to be a foreign merchant, period. So we're going to go back to this. And I think it's because there's one more on here. The term trust funds means funds held by an insured depository institution in a fiduciary capacity and includes, without being limited to, funds held as trustee, executor, administrator, guardian, or agent. The term trust funds means funds. Where are they getting the funds that back that which they are using in a fiduciary capacity in an insured depository institution within the United States corporation, and are using those funds in their holding capacity, warehousing capacity, as trustees, executor, administrator, guardian, or agent. Are you guys comprehending what this means? These are all synonymous. Everybody keeps wanting to use this executor. I'm the executor of the trust. Then that means you're the trustee. You're the one that's administrating the trust because somebody else already ministered the trust. Who ministered the trust? The grantor. He is the one that grants the powers to the trustee. He does, in fact, execute those powers, but he is not the executor. He is the grantor, to make clarification of the grant of all powers administrated by a guardian or agent in trustee position of funds he holds. Pure and simple. Now the next one, we can get rid of that one. The next one I want to talk about is general definitions under the Uniform Commercial Code, because we are talking about commerce. Creditor includes a general creditor. A general creditor, a secured creditor, a lien creditor, and any representative of creditors, including an assignee for the benefit of creditors, a trustee in bankruptcy, a receiver in equity, and an executor or administrator of an insolvent debtor's or assigner's estate. Representative means a person. empowered to act for another. Representative is only a fiction, including an agent, an officer of a corporation or association, and a trustee, executor, or administrator of an estate. In an executive capacity, you are only a representative. In the grantor capacity, you are the present, live soul being that all credit is granted from. Period. Money. Money means a medium. It's not the full amount. It's not the zero amount. It's a partial amount of exchange currently authorized or adopted by a domestic or foreign government. They authorized it, and by your use, you are adopting their foreign government money. It is an adoption process. The term includes a monetary unit of account established by an intergovernmental organization or by agreement between two or more countries. The state banks have an intergovernmental organization, and we are supposed to have an agreement between two or more countries as a foreign bank, because we operate our own trust as part of the duties of our own management of our own business, period. The next one we're going to go to is negotiable instrument. UCC 3-104. Except as provided in subsections C and D, a negotiable instrument means an unconditional promise or order. Every time that judge gives a discharge order, he's making an order to discharge. What is he discharging? He's discharging the negotiable instrument. Under an unconditional promise or order to pay a fixed amount of money. Fines, fees, penalties, and everything have already been fixed, and now you're broke. Get it? With or without interest or other charges described in the promise or order, if it is payable to the bearer or to order at the time it is issued or first comes into possession of a holder. Before you sign that order to discharge, or that order to do this, or that order to do that by the judge, I suggest you read it, comprehend it, amend it as necessary for the promise that they are trying to order you to pay. They're trying to order you to pay a promise. They cannot do that. Unscramble their twisted serpentine babble. Next one, it says, is payable on demand or at a definite time. These are your checks. because you put a definite time on there, a date. You've already signed it or issued it with a date on it saying that it is payable or transferable. Does not state any other undertaking or instruction by the person promising. Does not state any other undertaking or instruction by the person promising. This is your blank endorsement. You're not making any other instructions. If you want to do this correctly, comprehend what I'm telling you. Learn the words, learn how to construct this stuff, because they are telling you how to do this. They are telling you, does not state any other undertaking or instruction by the person promising. Means you need to state other undertakings and instructions by the person promising. The Federal Reserve is the one that's made the promise. The courts are the ones that are ordering you to pay that promise. You reconstruct the order for order for payment to show the person promising is the federal government. You never made any such promise. You never had any instructions to undertake such promise. To do any act in addition to the payment of money. But the promise or order may contain an undertaking or power to give, maintain, tain meaning hold, the holder, they are the main holder when they provide the instrument. You are the main holder that maintains the instrument if you are the one issuing the instrument. An undertaking or power to give, maintain, or protect collateral to secure payment. Meaning the payment has not been secured yet. It isn't secured until you sign it. An authorization or power to the holder to confess judgment or realize on or dispose of collateral. Dispose. They are posing the promise. You need to dispose the promise of your collateral by them. They have none of your collateral. They can't possibly have your collateral because they cannot secure payment because there is no way to make a payment. They can never secure payment, people. An undertaking or power to give, maintain, or protect collateral to secure payment. We already know payment can't be made. Or dispose of collateral. This is the controversy in court. Or a waiver of the benefit. This is what you're doing when you sign their documents. They're giving you a waiver of the benefit and you don't realize it. Of any law intended for the advantage or protection of an obligor. If you did not grant it, you are not the obligor. They are granting a promise. The Federal Reserve notes United States is the one granting the promise through their issue of their instruments. And you are partaking of that. You are partaking of their partial value of what you actually owe yourself as the obligor. You are the obligor in that situation. Certificate of deposit means an instrument containing acknowledgement by a bank that a sum of money has been received. Receivership. You get it, people? They have received. They are already in trustee position as a bank by the bank, and a promise by the bank to repay the sum of money. Certificate of deposit means an instrument containing an acknowledgement by a bank that a sum of money has been received by the bank and a promise by the bank to repay the sum of money. Certificate of live birth is a bank note. That note is the acknowledgement by the bank that a sum of money has been received because they issued the bank note, and you are the intended recipient of the bank note, as evidence that the bank has a promise to repay the sum of money. And it clarifies it as a certificate of deposit is a note of the bank. A certificate of deposit is a note of the bank. So look at your certificate of live birth. In the border, down in the bottom left corner, in fine print, it's going to say something like Midwest Banknote Company or American Banknote Company. This is what tells you it is a note of the bank. And it is in certificate form. They have deposited it to position. They have given up their holding of it and sent it to a recipient that they intended to send it to, and therefore posited it with them. You have a certificate of deposit, which is a promise by a bank to repay the sum of money per their note. Section 8 of the United States, or UCC, and we're going to look at Section 9. Says financial asset, except as otherwise provided in Section 8-103. Rules for determining whether certain obligations and interests are securities or financial assets. Obligations, securities, none of this mentions any assets. Why? Because the United States has no assets. If they are insolvent and delinquent by bankruptcy, they cannot possibly have assets. That's why it says obligations and interests are securities or financial assets. Securities or financial assets. Financial asset, except as otherwise provided in Section 8-103, means a security. Okay, first of all, you don't have an obligation. You have a security known as an asset. That asset, folks, is your signature. They are dependent upon your signature. An obligation of a person or a share, a partial quantity of something, a share, everybody sharing equally, they each have one partial participation or other interest in a person or in property or in enterprise of a person, which is or is of a type dealt in or traded on financial markets, or which is recognized in an area in which it is issued or dealt in as a medium for investment. Dealt in or traded on financial markets. Do they trade Federal Reserve notes on the financial markets? No. Or which is recognized in any area in which it is used or issued or dealt in as a medium for investment. Investment is an exchange. Any property that is held by a securities intermediary for another person in a securities account, if the securities intermediary has expressly agreed with the other person that the property is to be treated as a financial asset under this article. As context requires, the term means either the interest itself or the means by which a person's claim to it is evidenced, including a certificated or uncertificated security, a security certificate, or a security entitlement. The certificate of live birth, authenticated, both state and federal level, coming back as full faith and credit. Full faith and credit to the actual creditor. Period. So that was it for that one, I believe. And you guys can get these links and go on and read what that security entitlement is. When we look up here as at financial asset, and it says securities intermediary, securities account, financial asset, uncertificated security, security certificate, or security entitlement. Let's go ahead and read this one just to Security entitlement means the rights and property interest of an entitlement holder with respect to a financial asset specified in Part 5. Clearing corporation, a person that is registered as a clearing agency under federal securities laws. Let me show you something, folks. 31 CFR 363.1. What is a Treasury Direct registered account? Treasury Direct account is an online account maintained, there we go, maintained by them, by us, solely in your name, in which you may hold that certificate of live birth and conduct transactions in eligible book entry Treasury securities. Registered as a clearing agency under federal securities laws. When you authenticate the certificate of live birth, let me show you what happens. That's 31 or section Title 31 of the United States Code, section 363.10. And if we go to 3163.63, or excuse me, 0.6, it says, what special terms do I need to know to understand this part? Account means a Treasury Direct registered account as described in 363.1, which is what I just read. And in reference to the authentication of the certificate of live birth, authentication means confirming that the person accessing a Treasury Direct account is the same person whose identity was initially verified at account establishment. When this account was established, there was a person that opened it. As a clearing agency under the federal securities laws, a Federal Reserve Bank, or any other person that provides clearance. What did you do when you authenticated the certificate of live birth? You provided clearance or settlement services with respect to financial assets that would require it to register as a clearing agency under federal securities laws. But for an exclusion or exemption from the registration requirement, if its activities as a clearing corporation, including promulgation of rules, are subject to regulation by federal or state governmental authority. If its activities as a clearing corporation, including promulgation of rules. What is promulgation? Promulgation is the formal toward forward claim, action of the forward claim in form or declaration that a new statutory or administrative law is enacted after its final approval. This additional step is necessary before the law can take effect. So what you're doing here is you're promulgating with them, and you are subjecting them to their own rules by agreeing, because you provided the clearance with respect to the financial assets. You are the one that did it by your authorization and authentication of the certificate of live birth here, folks. Communicate means to send a signed writing or transmit information by any mechanism agreed upon by the person transmitting and receiving the information. When you communicate with them and they send you as the entitlement holder and intended recipient, they know you will hold that certificate. What you do next, you need to provide that clearance. Otherwise, you don't have clearance. They are operating under executorship and administration. You have to provide the clearance with respect to the financial assets as the grantor. Comprehend that, people? Okay, does it say anything else about 8? No, it does not. So now we're going to go on to the last one here, which is Title 9. Section 8 of the UCC is in regards to security instruments. 9. 9, I believe, is in reference to, 9 is secured transactions. 8 is investment securities. Okay, that would be your actual assets, because they can't actually invest in anything unless they have a substantive asset. And that's why I say they're investing in you, because they have nothing backing their Federal Reserve notes. They have to be able to invest in you. You are not investing in their system. You are promulgating their system by your clearance in respect to the financial assets that they initially invested in. And that's why they have the obligations and other securities through the use of the Federal Reserve notes. So 9 is the secured, I'm thinking too fast, people. The secured transaction, and the Section 8 is the actual investment. They're calling everything that they do now secured transactions. What about that thing we saw earlier, secure payment? They can't secure payment because they can't transact with the assets. They can only transact the partial value, which is the obligation of the security instruments, things that they instrumentalize to secure payment in the future. That's all it is. And so when we look at Title 9 here, we're looking first at Section 9. Which they don't, in this writing, they didn't mention the section I actually want to go over first, which is authenticate, which is what we just read in the Code of Federal Regulations. This is UCC. And like I say, UCC is uniform. It mentions right in the UCC that the UCC is to be uniform throughout all jurisdictions. And as we saw in 31 CFR, the authentication means to sign or with present tense to adopt or accept a record, promulgate, it's the same thing. You're going to accept their record, to attach to, or logically associate with the record an electronic sound, symbol, or process. We're going to change the symbols in our process and electronic sounds by changing the words we use, by letting them know that we understand or comprehend that to adopt or accept a record is to promulgate, as it says in Title 31 CFR 363.6, under the same definition, authenticate. Then it says 9. Let's read bank just for everybody's shits and giggles. We read bank in the United States Code. In the UCC, it means an organization that is engaged in the business of banking. The term includes savings banks, savings and loan associations, credit unions, and trust companies. What did I tell you in reading the U.S. Code definition of bank? Is that I told you all banks operate as trust companies. And here in the Uniform Commercial Code, it is telling us and trust companies. 9, cash proceeds means proceeds that are money, checks, deposit accounts, or the like. Again, we're talking about something like, the same type, familiar. Deposit, again, they deposited the certificate of live birth with yourself as the intended recipient, and there is a communication, there is an account of that. It is a deposit account, and it is accessed through the authentication. And there is a certificate of title. Means a certificate of title with respect to a statute. That puts me out of the question. But if I'm going to promulgate those statutes, providing for the security interest in question to be indicated on the certificate as a condition or result of the security interests obtaining priority over the rights of a lien creditor with respect to the collateral. So, when I issue a certificate of receivership, I am accepting your statutes. I'm going to indicate on the certificate of receivership as a condition or result of security interest that I am maintaining or obtaining. Same thing, withholding. I am holding with priority over the rights of the lien creditor with respect to the assets which are the actual collateral, because they have no collateral, because they can only use obligations to secure any type of collateral. And since they're in bankruptcy and being insolvent, that collateral can only be an interest to recoup through liquidation. for payment to the actual creditors that they owe. The term includes another record maintained by an alternative to a certificate of title by the governmental unit that issues certificates of titles, if a statute permits the security interest in question to be indicated on the record as a condition or result of security interests obtaining priority over the rights of a lien creditor with respect to the collateral. Alternative to a certificate of title by a governmental unit that issues certificates of title. Alternative. Another record maintained as an alternative. What is that other record? That would be the Federal Register. The state is the one that sends you the certificate of live birth, and didn't we just see under federal regulations that it is a securities account held in your name by them? Therefore, it is another record, and through authentication, proving the identity of the applicant on the state level is the same person accessing the federal account. Thereby, that certificate of live birth is your certificate of title. Your certificate of receivership that you send to them, indicating on the certificate the conditions, your conditions, that result the security interest obtaining priority over the state, who is the lien creditor with respect to that particular collateral, because they're the ones that sent you the certificate of live birth that is then authenticated under full or given full under state and federal levels and given full faith and credit. That is your certificate of title. You then issue them a certificate of receivership saying that you received the certificate of title and accept their record, their accounting, saying that they are the trustee under Title 31, and they opened the account in your name, and that through authentication, you have access to that account under full faith and credit. And it should be merely a matter of sending your bill for MediaCom, for utilities, your loan agreement with the local car dealership, or I suggest making an agreement with directly with a manufacturer to clear up the MSO, MCO certificate of title in that situation, so it does not get sent to the state. But rather, you should be able to send these, and I don't have this in operation yet. This is just principle according to the way they wrote it. We should merely be able to send that bill along with a draft of an order to pay for the securities account trustee to do the discharge according to the law, period. That way we don't have to hand over our Federal Reserve notes or write a check off of our local bank account. Period. Okay, then it talks about 11. So I've talked about 7, 8, 9, 10. 11 talks about chattel paper. Chattel paper means a record or records that evidence both a monetary obligation and a security interest in specific goods. The specific goods in relation to what we are speaking on in regards to private American nationals or private state and nationals, however you want to state it. I'm a live living soul under our Father in heaven, and granted dominion in earth as it is in heaven. a security interest in specific goods, and software used in goods, and security interest in specific goods. Specific goods would be your assets that you indicate. You have to specify them. You have to indicate them. And license of software used in goods. A lease of specific goods. The driver's license. Marriage license. Those are all lease agreements wherein you give the state an agreement to be able to use certain aspects, or a lease of specific goods and license of software used in goods. And what I want people to pay attention to here is software used in goods. Every program on every computer in every stage has some kind of security certificate written into the program. It is a transfer of information. You open the page that they offered to let you view and accepted everything on that page in formation of contract. Every time you click a link, there is an offer made and you are accepting it in formation of contract if you put on information on that page and sign a signature. That is a valid contract according to this. So be aware. Just a note. In this paragraph, monetary obligation means a monetary obligation secured by the goods or owned under a lease of the goods, and includes a monetary obligation with respect to the software used in the goods. Remember that 31 CFR 363.1, it says it's an online account. This is where the security certificates exist for that online account. The certificate of live birth is a definitive bond. It is a paper form. And what you do is you have them convert a bond to electronic form. And that gives it a security certificate if it's done right. The term does not include charters or other contracts involving the use or hire of a vessel, or records that evidence a right to payment arising out of the use of a credit or charge card, or information contained on or for use with the card. Because all the information first names the state or the United States. Look at your driver's license. It's going to have the state name on it first. It first applies to them. Your U.S. passport, it's going to have United States on it first. It first applies to them. So chattel paper is not going to include anything that applies to them first. The documentation behind that, when you went to the DOT and committed to the test and wrote your answers down on that test and then signed that document, instrumentalized it for them to make a license card, which we have recently viewed. Many different states now have licenses with a little electronic strip on the back for security certificates for transactions, just like a credit card And therefore there's a 4-digit PIN that we're supposed to be able to use once we correct our situation, so we can use that driver license as that payment. If a transaction is evidenced by records that include an instrument or a series of instruments, the group of records taken together constitutes chattel paper. When you go to the driver's license office, you fill out this paper, and then you fill out this paper, and then you sign this paper, and you take a test, you take a driving test, and then they tell you if you passed. Every last bit of it are series of instruments. That series of instruments includes your registration of the automobile and the insurance that you get upon registration, proving that you can now get a license to drive. It's all a series, and that's all called chattel paper. That's all it is. But it evidences both monetary obligation and a security interest. They cannot secure payment because you have a security interest that is superior, because their obligation is a partaking through their monetary system, which states they are obligated through everything that they partake in. Includes all bonds, certificates of indebtedness. And when it comes back under full faith and credit, it shows that indebtedness is due to the full faith and credit clause under United States Constitution, Article 1, Section 8, I believe. Let's see. The next section here it talks about is 12B. Accounts. Collateral means the property subject to a security interest or agricultural lien. Notice that, folks. Look at this. If you look up 31 CFR 363.1 and get lazy and don't put that 0 on it, it's not going to bring you to what you want. Regulations in this part apply to book entry Treasury securities held in the Treasury Direct Registry or registered system. Book entry is electronic entry. That's all that is. So pay attention when you're searching this stuff. When you have digits to put in your codes and stuff, make sure you put all the right digits. And it says, what is a Treasury Direct account? Maintained by us solely in your name. Collateral means accounts. So that is a collateral. And when you indicate the actual assets of that account, you get rid of the chattel paper. You get rid of the payment intangibles. You get rid of the promissory notes. Any chattel paper from now on should be kept by yourself as part of your record-keeping system. Period. It is now private. They are just a broker through receivership, and they are only to partake of their duties on making the transaction and nothing else. No further assignments of powers of attorney to anybody else or anything. Just their duties to make the actual financial transaction, and that is it. It also says 49 and 64. We're going to look at a couple more in the meantime, I think. Remember, we saw communicate means to send a written or other tangible record, to transmit a record by any means agreed upon by the person sending and receiving the record, or in the case of a transmission of a record to or by a filing office, to transmit a record by any means prescribed by filing office rule, to transmit a record by any means agreed upon by the person sending and receiving the record. Remember, I talked about electronic records. They have security certificates. They have time records that will tell you when you communicated with the Secretary of State and sent them a payment via electronic means to receive, as intended recipient, a certificate of live birth. You communicated with them. That is an electronic record. It is now part of the chattel record that you have, that you can print off as chattel paper to show those time spans or time marks in proving that they received it, they sent it, and you received it, you had it authenticated. It all now becomes part of your record. You need to keep track of these communications, part of your record. Debtor, a person having an interest other than interest or other lien. Okay? They cannot possibly put a proper and valid lien on yourself. They can only put a lien on the instrumentalities. And so therefore a debtor is never yourself. Ever. Ever. It is a person. Always going to be a person. You as a man have an interest, a security interest, that is superior and a greater priority than any personal interest. Period. No matter whether it be the state or the federal government. Doesn't matter if your interest is only a matter of $1 million and the federal government's interest is $100 million. It makes no difference. You are not the debtor. They are. Deposit account, remember? Deposit account, your record of them depositing that certificate of live birth with you is your account. It is a deposit account where they deposited. They sent it away to an intended recipient, away from their position to your account. Means a demand, time, savings, passbook, or similar account maintained with a bank, and that bank can be a foreign bank. Remember, your bank, your account. It is in your deposit account. The term does not include investment property. The term does not include investment property, only the accounting thereof, or accounts evidenced by an instrument, or accounts evidenced by an instrument. They are only evidenced by documents. Document means document of title, or a receipt of a type described in section 7-201, person that may issue a warehouse receipt. Storage under bond. A warehouse receipt may be issued by any warehouse. The state is the warehouse. They sent you a receipt to the intended recipient. You received it. If goods, including distilled spirits and agricultural commodities, your sweat equity labor, are stored under a statute requiring a bond against withdrawal, or a license for the issuance of receipts in the nature of warehouse receipts. A receipt issued for the goods is deemed to be a warehouse receipt, even if issued by a person that is not the owner of the goods and is not a warehouse. A receipt issued for the goods is deemed to be a warehouse receipt, even if issued by a person that is not the owner of the goods and is not a warehouse. I am the owner of the goods. They are my true assets. And therefore it is a warehouse receipt. I received it. Electronic chattel paper means chattel paper evidenced by a record or records consisting of information stored in an electronic medium. That's what I was talking about a little earlier. Instrument means a negotiable instrument or any other writing that evidences a right to the payment of a monetary obligation, is not itself a security agreement or lease, and is of a type that in ordinary course of business is transferred by delivery with any necessary endorsement or assignment. Certificate of receivership that I was talking about earlier. Endorsement or assignment. That certificate of receivership, you're going to give them a assignment. The term does not include investment property, letters of credit, or writings that evidence a right to payment arising out of the use of a credit or charge card, or information contained on or for use with the credit card. You have to go through the actual assignment. So if you have a credit card or information like that, you can't go through them. You have to go through the main security holder, TDA, the main trustee. You have to quit going through the state trustee, and everything goes through the federal trustee. 49 here says investment property means a security. Security, that's all it is. Whether certificated or uncertificated. So does it have to be on paper or not? No. All you have to do is clarify. You have to indicate your assets, whether certificated or uncertificated. Security entitlement. Are you entitled to that certificate of live birth, and are you entitled to have it authenticated at state and federal level per law, and have it be transacted from that point on under full faith and credit as the instrument it was meant to be used as, under a securities account. Under a securities account which you may hold and conduct transactions in eligible book entry treasury securities. means a security. So all you need is a security. The certificate of live birth authenticated is certificated, and authenticated means they have no way to rebut the security. It is full faith and credit, and it is investment property. The next one says 64. Lien creditor. A creditor that has acquired a lien on the property involved by attachment, levy, or the like. So, a lien creditor is somebody that is making a claim of a debt. You cannot possibly be the lien creditor on your own property, people. Remember, if you're doing the UCC1 and you're listing yourself as a lien creditor on property, you better not be listing your own property on there, because that's a fatality. You are the creditor ab initio before any lien was put on it. An assignee for benefit of creditors from the time of assignment. If you're going to put a lien creditor on a UCC1, it has to be your person, with you as the creditor. A trustee in bankruptcy from the date of filing of the petition. Anytime they profess they are the lien creditor, the entire banking system is in fact bankrupt. And so they are taking on the position of a trustee in bankruptcy from the date of the filing of the petition, or a receiver in equity from the time of appointment. They cannot be a receiver in equity if they are not willing to admit the true assets of the true investment property and the actual value. And this means that through their cognitive dissonance of being instituted through their entire life of propaganda, using Federal Reserve notes and believing that's a way to pay, they cannot possibly, through their ignorance, become as a receiver in equity. This is why you issue the Treasury Direct, the Department of the Treasury, a receivership in equity, a certificate of receiver in equity under full faith and credit. I have evidence in my account, shadow paper, from your records that state that account that you hold that you maintain in my name says I can now hold and conduct these said transactions. Make it so, Capitan. Pure and simple, people. And I think that's it. Yeah. So anyway, I know this was a little bit longer video, but I'm hoping the people that are watching will go back and watch the whole thing. I know it gets, even myself, I don't like watching hour-long videos, but I hope it's important enough that you'll go back and watch it, go back and watch it, go back and watch it. And get the gist of it. Go do your research. Don't believe me. Don't believe the government. Don't believe your neighbor. Don't believe anybody. Like I tell you, do your own research so you can get over believing and discern for yourself the true facts, so you can actually move forward and experience this stuff with knowledge, so you can trace back your steps with wisdom, so you can show others how to do the same thing. That's what I'm trying to do myself. Again, I didn't mean for it to be this long. I knew there was going to be a lot of information, and so I'm going to put it out. I don't like breaking it up into smaller videos. I prefer that you do your research by watching the video over and over and catching little parts. Just like when you go out to the movie theater and you watch a movie like Star Wars 17 times. Every time you watch it, you're going to catch something new that you missed before. So please, think about this stuff. And again, when I get done here, I'm going to post my other the links to my other forums and my PayPal link for those that want to send me gratuities. But in the meantime, I gotta see if anybody's. See, this is so. Got all these people that are supposedly watching, but nobody's commenting. And this is what I need. I keep telling you guys, I need your comment. Joshua Rogers says yes. Says this is saying basically that Disneyland can make and sell Disney dollars. Yes. Okay. Perfect example. I appreciate that. Because when you go to Disneyland and you give them a $50 bill and they give you this strip of coupons that you can go ride so many rides. Those coupons, guess what, people? Coupons, comma, coupons, comma. Think about that, people. The difference is, and just like the United States, you can only use those coupons at Disneyland. When you go to Disneyland and you trade that $50 for 50 coupons, and you go through Disneyland and you don't spend those dollars, those coupons, and you go walk out that gate and you don't transfer them back, you can't go out and use them at McDonald's. And when you walk out that gate, is Disneyland going to be willing to convert them back into dollars? Did you just get suckered because you yourself decided not to use those coupons appropriately? That's what the United States is doing. Except they've extended the use of their Federal Reserve notes beyond Disneyland and has everybody thinking that it's all worlds of fun. How convenient. How convenient. Well, I don't see, God, that's the only comment about amongst all of you. Thanks, guys. I appreciate that. I really do. Sorry if it sounds insulting, but I keep telling you guys, I need your input. I need to know your questions. I need to know your responses. So in the meantime, like I said, I do know that it's been a long enough video. I'm not going to go any further. As soon as I get done clicking out of here, I'll post those other forums that I have, as well as that PayPal link, and hope that people will hit that PayPal button and send me some gratuities. In the meantime, like I said, I also apologize for not getting that Zoom meeting in last night due to a internet outage here locally. It had nothing to do with the phone services that were going on yesterday. And remember, if it wasn't for you guys, I wouldn't be doing this. God bless. Love you all. Have a great day.